You've probably heard the term independent contractor thrown around a lot. Maybe you drive for a rideshare company, pick up freelance jobs online, or do construction work under a contract. But here's the big question workers often ask. If I'm not an employee, what rights do I actually have? This is a crucial topic because independent contractors don't enjoy the same protections as employees under U.S. labor law. You don't get minimum wage or overtime under the Fair Labor Standards Act, and you're not covered by laws like the Family and Medical Leave Act or Title VII of the Civil Rights Act. But that doesn't mean you have no rights at all. In this video, we'll explore 4 things. 1. How the law defines independent contractors versus employees. 2. What rights independent contractors do have under U.S. law. 3. The risks and limits that come with contractor status. 4. Practical steps to protect yourself when working as a contractor. Part 1. The basics of overtime under federal law. When we talk about overtime pay, the first place we need to look is the Fair Labor Standards Act, FLSA, the main federal law that sets minimum wage and overtime standards in the United States. Under the FLSA, the general rule is straightforward. If you are a covered, non-exempt employee, you are entitled to receive time and a half, that's 1.5 times your regular hourly rate, for every hour you work beyond 40 hours in a single work week. Now, let's break this down carefully. The FLSA defines a work week as a fixed and regularly recurring period of 168 hours, 7 consecutive 24-hour periods. That means overtime is calculated week by week, not averaged over 2 weeks or a month. For example, if we work 45 hours in 1 week and 35 the next, we're entitled to overtime for the extra 5 hours in the first week, even if the 2-week total averages to 40 hours per week. The law also makes clear that overtime pay must be based on our regular rate of pay. That includes not just hourly wages, but certain bonuses, commissions, and incentive pay. Employers can't simply ignore those when calculating overtime. For instance, if we make $20 an hour and also earn a $100 productivity bonus for that week, the bonus has to be factored into the regular rate before multiplying by 1.5 for overtime. It's also important to note that not all workers are covered. The FLSA has exemptions, meaning some employees are not entitled to overtime under federal law. The most common exemptions are known as the white-collar exemptions, which apply to executive, administrative, and professional employees who meet both a salary test and a duties test. As of 2025, the salary threshold under federal law is $684 per week, about $35,568 per year, though some states have higher thresholds. If we earn less than that amount, chances are we must be paid overtime no matter what duties we perform. Example: let's imagine Maria, who works as a retail associate making $18 an hour. Last week, she worked 48 hours. Under the FLSA, her employer must pay 40 hours at $18 plus 8 hours at 27 time and a half. If her employer only pays her straight time for 48 hours, that's a violation. Key takeaway: at the federal level, overtime rights are clear. Non-exempt employees working more than 40 hours in a week are owed 1.5 times their regular rate. The challenge comes in figuring out whether we are truly non-exempt or misclassified, which we'll explore in the next part. Part 2. Who is exempt and who is not? Now that we've covered the basic rule that most employees must receive time and a half after 40 hours per week, let's talk about the exceptions. Under the Fair Labor Standards Act, FLSA, some workers are considered exempt, meaning they are not legally entitled to overtime pay. Understanding these exemptions is crucial because misclassification is one of the most common problems workers face. The white-collar exemptions. The biggest category is called the white-collar exemptions. Executive, administrative, and professional employees. To qualify as exempt, 2 tests must be met. 1. Salary basis test. The worker is paid a fixed salary, not hourly, that meets the federal threshold of at least $684 per week, about $35,568 per year. Some states, like California and New York, require higher minimums. 2. Duties test. The worker's job duties must primarily involve management, independent judgment, or specialized professional knowledge. For example, a store manager who supervises employees and has authority over hiring and scheduling may qualify as exempt. Other exemptions. Beyond white-collar roles, the FLSA also exempts outside sales employees who primarily work away from the employer's place of business. Certain computer professionals, if paid above a specific hourly or salary threshold. Some transportation workers like truck drivers, who may be covered by other laws such as the Motor Carrier Act. Misclassification problems. Here's where things get tricky. Many employers wrongly label workers as exempt to avoid paying overtime. Just having the job title of manager doesn't automatically make someone exempt. If we're stocking shelves and running the cash register most of the time, even with the title assistant manager, we may still be legally entitled to overtime. Example, let's say David works as a restaurant shift supervisor. He earns a salary of $700 per week and often works 55 hours. If his real duties mostly involve serving customers, cleaning tables, and taking orders, with only occasional scheduling tasks, he may not meet the duties test. That means he could be misclassified and still owed overtime pay for the extra 15 hours. Key takeaway: being exempt is not about what your employer calls you. It's about what you actually do and how you are actually paid. If you're working long hours but your duties don't fit the exemption tests, you may have the right to claim overtime pay. Part 3. State laws and how they expand overtime rights. While the Fair Labor Standards Act, FLSA, sets the federal baseline for overtime, states are free to create their own rules, and many do. That means our rights may depend not just on federal law, but also on the state where we work. States with stricter rules. Some states go further than federal law to protect workers. For example, California, one of the strongest states for overtime rights. Workers must be paid time and a half after 8 hours in a single day, not just after 40 in a week. Double time applies after 12 hours in a day or after 8 hours on the 7th consecutive workday in a week. Colorado requires overtime after 12 hours in a day or 40 in a week, whichever is greater. Alaska and Nevada also require daily overtime after 8 hours, higher salary thresholds. States can also raise the salary threshold for exempt employees. For example, in New York, as of 2025, the minimum salary to qualify as exempt in New York City is more than double the federal level. In California, the threshold is tied to the state minimum wage, meaning many salaried employees who would be exempt under federal law still qualify for overtime under state law. Example of state impact. Let's imagine Sarah works as a warehouse employee in California. She earns $20 an hour. If she works 10 hours in a single day, she gets 8 hours at $20, plus 2 hours at $30, time and a half. If she pushes to the 10 hours, the last hour is paid at $40, double time. Under federal law, Sarah wouldn't see overtime until she hit 40 hours in a week. But California law gives her daily protection. Industry-specific rules. Some states also create overtime rules for specific industries, such as healthcare or hospitality. For instance, nurses in certain states are protected from being forced into excessive overtime shifts. Key takeaway: overtime rights aren't one size fits all. Federal law gives us the foundation, but state laws can expand those rights significantly. To know if we qualify, we have to check both. Workers in states like California, New York, and Colorado often have stronger protections than the federal standard. Part 4. How to protect yourself and what to do if you're denied overtime. Even when the law is clear, many workers struggle to actually receive the overtime pay they've earned. That's why it's important that we know how to protect ourselves and what steps to take if an employer refuses to comply. 1. Keep accurate records. The first line of defense is documentation. We should always keep track of our hours worked, when we clock in, when we clock out, and any extra time we put in before or after shifts. Even if an employer keeps official time records, having our own backup strengthens any future claim. 2. Understand your classification. As we discussed earlier, misclassification is a huge problem. If we're being called an independent contractor or an exempt manager, but we don't actually meet the legal tests, we may be losing overtime rights. Reviewing the FLSA standards and our state's laws can help us spot when something doesn't add up. While the issue internally. Sometimes overtime problems are the result of confusion rather than intentional wage theft. If we feel safe doing so, we can bring the issue to HR or payroll and point out the discrepancy. In some cases, employers correct mistakes quickly once they know we're aware of our rights. 4. File a complaint. If an employer refuses to pay overtime properly, we can file a complaint with the U.S. Department of Labor's Wage and Hour Division, WHD. This agency enforces the FLSA and investigates wage violations. We can also file with our state labor agency if our state has stronger overtime rules. These complaints can often be made confidentially, and retaliation for filing is illegal. 5. Consider legal action. If complaints don't resolve the issue, we may have the option to bring a lawsuit in court to recover unpaid wages, liquidated damages, essentially a penalty equal to the unpaid wages, and attorney's fees. Many states allow workers to band together in class actions when the same employer is denying overtime to large groups of employees. Example: imagine Robert, a warehouse worker who consistently works 50 hours a week, but only gets paid straight time. He documents his hours and raises the issue with HR. When nothing changes, he files a complaint with the Department of Labor. The investigation confirms the violation, and Robert receives back pay for 2 years of unpaid overtime. Key takeaway: overtime rights only matter if we enforce them. By keeping records, knowing the law, and taking action through agencies or courts, we can hold employers accountable and make sure we're paid what the law requires. So, do we qualify for overtime pay? The answer depends on how we're classified, how much we earn, what our duties are, and even which state we work in. Under the Fair Labor Standards Act, most non-exempt employees must receive time and a half for hours over 40 in a week. State laws like those in California or Colorado can expand those rights even further. The key is knowing our classification, keeping accurate records, and being willing to speak up if something seems wrong. Employers can't legally avoid paying overtime by mislabeling workers or ignoring the law. If this video helped clarify your rights, hit like, share it, and subscribe for more plain guides to workplace law.